Hello, thank you for joining us today for the Ford Richardson webinar, Hot Topics for Municipalities. And I'm going to now turn you over to Scott Ford, who's going to get us started. Scott?
Great. Thank you, Susie. I didn't know when we were going to do hot topics that it was going to be as warm as it is in Richmond today. I think it's almost 77 degrees, but this is the first time we've done this program, and so we had excellent reaction to it. I think we had about just under 200 that registered, so thank you for your interest. We have a nice panel representing our various offices across Virginia, Audrey Marcello in our Hampton Roads office, Flavina Alcoa in Northern Virginia, Brian McNamara is in our Roanoke office and is one of our presenters, and then finally Brian and I. We did pick a handful of topics. We're going to move through them pretty rapidly. There's a lot of good information here. We're going to try to cover it in the short time that we have. We're going to talk about presumptions and then dive into LODA, VRS, SSDI, and how that intersection impacts workers' compensation, and then round it out with a variety of miscellaneous issues that are specifically targeted to municipalities. So without further ado, I will pass it to Audrey. In this first section, Audrey and I will be presenting, but most of it will be with Audrey. So Audrey, I'll turn it over to you.
Thank you, Scott, and thank you everyone for joining us on this presentation. Since we don't have a lot of time, I'm going to move quickly through, but I do encourage anybody to ask any questions in the Q&A box, and we will go ahead and address those as they come in. This topic is presumptions under the Act and the recent updates that have come forward out of the General Assembly, which do have a great impact on municipalities as they mainly focus injured workers who are employed by municipalities. So we can go to the next slide. An overview of what those presumptions are. So the General Assembly has provided for coverage for injured workers who have certain diseases and conditions that are presumed to be causally related to the employment when diagnosed for certain employees. In order to be under the presumption, you need to be a covered employee, and there must be a diagnosis and disability resulting from the disease. And normally this covers emergency response personnel, police officers, other law enforcement personnel, and certain government employees. And the conditions that are subject to the presumption include certain cancers, not all, respiratory diseases, certain infectious diseases, hypertension, and heart disease. So what that means is that the General Assembly has made a minimum burden for the employee to prove compensability. And under the cancer presumption, under the respiratory diseases presumption, that covers certain diagnoses such as pulmonary sarcoidosis, carcinoma of the lung, emphysema, and that is only applicable to voluntary and salaried firefighters and hazardous materials officers. So that is fairly limited to certain personnel. Specifically, you would find it mainly with volunteer and full-time firefighters. For heart disease, it is extended to both firefighters, law enforcement, police, hazardous materials officers, ABC special agents, port authority officers, and airport officers. And for heart disease, the specific diagnosis are tachycardia, irregular heart rhythm, cardiac arrhythmia, cardiac spasm, or coronary artery spasm. And I guess what I would say under that presumption is to be sure that the heart condition that the person has been diagnosed with is actually a form of heart disease, and that should be clarified by a physician. Under section 65.2402B, there is also a presumption for hypertension that covers the same employees as under heart disease, to include law enforcement, police officers, firefighters, etc. It must be based upon 3 consecutive daily or weekly blood pressure readings, and a stroke can be considered a compensable consequence of hypertension. And again, it is necessary to also have disability related to the hypertension. So many people have hypertension and have no disability related to that, and thus they would not be covered under the presumption. You can go to the next slide. Also under 65.2402C, there is a presumption for certain types of cancers, and that is for voluntary and salaried firefighters, hazmat officers, motor carrier safety troopers, full-time sworn members of the Department of Motor Vehicle Enforcement Division. There is a requirement, which is new, that they must have 5 years of continuous service to qualify and to be eligible for the presumption. And there has also been an addition of several cancers. So now the cancers that are covered include leukemia, pancreatic cancer, prostate cancer, rectal cancer, throat cancer, ovarian, breast, colon, brain, and testicular cancer. And what was changed in the 2020 amendments, previously there was a requirement that the claimant had to prove contact with a toxic substance in order to be eligible for the presumption. That was taken out. So prior to July of 2020, an injured worker must show contact with a suspected carcinogen or toxic substance in order to be eligible. After July of 2020, they do not. Can we go into the next slide?
Real quick, Audrey, just 2 points. One, should be reminded that colon, brain, and testicular cancer, the presumption does not apply for any diagnoses for those conditions before July 1 of 2020. And I would also just remind folks that these presumptions are all rebuttable presumptions. So while the claimant may get the benefit of the presumption, the burden then shifts to the employer. So if the employer can establish both that the diagnosis is not related to work, and second, that it's related to a non-work related cause or causes, then you will have successfully rebutted the presumption. So just remember that point.
Correct. And I'll kind of go into how to defend these types of presumptions and what you need to know in order to do that. But moving on to the next one under section 65.2402.1, that is coverage for infectious diseases for volunteer and salaried firefighters, law enforcement, hazmat officers, ABC special agents, and other certain types of law enforcement officers. And that is for infectious diseases such as hepatitis, ABC and other strains, a certain type of meningitis, tuberculosis, and then also HIV. And there is an exposure requirement for infectious diseases. There must be documented exposure, occupational exposure to blood or bodily fluids. And so it must be documented at the time in which that exposure occurs for the presumption to be afforded for the injured worker. So there were new amendments which also added under 65.2402.1B2 for a COVID-19 presumption. That amendment provides for a presumption for healthcare workers, firefighters, and law enforcement. The individual must have symptoms of COVID-19 that require medical treatment. And there's no presumption unless the person is immunized or vaccinated. The presumption only applies for persons after March 12th, 2020, and then persons claiming the presumption after July 1st, 2020 need a positive test plus symptoms.
And let me jump in real quick. I've not seen any cases dealing with the presumption for COVID that have reached the commission. I don't know if the team of lawyers have seen any, but we did have one at our firm prior to the presumption, that was Roundtree versus Tradition Senior Management, June 9 of 21, where we were successful under the the old provision, which would have been the ordinary disease of life statute. And other than the Roundtree case, the only other one that I saw come out of the commission was Donna Brown versus Sunnyside, which was October of 2021. So if you're interested in seeing those opinions, I think there are only two.
Yeah, there's not much that's come back to the full commission on COVID as of yet. So nothing really has come up to the full commission where they've issued an opinion on that. So it'll be interesting to see what comes out of that. Moving on to the next slide, there is also a new presumption for post-traumatic stress disorder for law enforcement officers and firefighters, and that is listed in section 65.2107, and that allows for a presumption for incidents on or after July 1st, 2020. And there's a list of various events that would qualify that person for presumption for PTSD, serious bodily injury or death to any person or persons, events involving a minor who's been injured, abused, killed, or exploited, events involving an immediate threat to life of the claimant or another individual, involving mass casualties, or responding to crime scenes for investigation. So as you can imagine, this certainly broadens the number of claims that we can expect for a presumption for post-traumatic stress disorder. There are exclusions as set out in the Act under 107, and the exclusions are that the PTSD cannot be the result of disciplinary action, a work evaluation, job transfer, demotion, promotion, termination, retirement, or a layoff. And so in order to be qualified for a presumption for PTSD, if you could move to the next slide, the claimant must show one of those qualifying events, which I listed, while acting in the line of duty, and there needs to be a mental health professional who has diagnosed him or her with PTSD as a result of the exposure to that qualifying event. And that person who has diagnosed them must be a board certified psychiatrist or psychologist pursuant to Code Section Title 54.1 and as required under 65.2107. So it can't be a social worker or a counselor. And the General Assembly, when they made this amendment and expansion for PTSD for law enforcement personnel, have at least limited the number of benefits that an injured worker who's claiming an awarded PTSD benefits. The benefits will be provided for a maximum of 52 weeks from the date of diagnosis, and no lost wage benefits shall be awarded beyond 4 years from the date of the qualifying event. So what that means there is the most that injured worker can get under a claim for PTSD is 52 weeks. So if they need to take off 3 weeks here, they have an event in which their doctor takes them out of work for 2 months, and then they can go back to work and are released. The total amount that they can get over the course of 4 years cannot exceed 52 weeks. And also, this is interesting, that the medical benefits also cease after 4 years after the qualifying event. So no more lifetime medical benefits. It is curtailed only for 4 years after the qualifying event.
And I'll just jump in. One thing that's surprised me with regard to this new presumption is we have not seen as many cases as we had anticipated. And I'm only aware of the one case, and Audrey, I know it's in the material, so we'll chat about it, the Cody Hall decision, but I think that's the only one I've seen at the full commission.
Yeah, I didn't see a lot of cases, and it might be because the amendment is so new, but it also might be that, you only get a year of benefits. So you're not going to be able to be taken out of work for years and years. So it could be many reasons. Let's move on to the next slide. All right, so I'm kind of going to switch gears a little bit and talk about what to do when you're investigating a claim for these types of presumptions, specifically for hypertension and heart disease. you're going to want to get, actually for all of them, you're going to want to get the recorded statement and specifically ask the injured worker, when did the doctor tell you that your heart condition, that your hypertension, that your condition was related to work? Because that's the date of injury for the commission, and that is where the statute of limitations is measured by. So the date of communication is, or date of communication to the employee that their condition may be related to work is the date of accident in the commission's file. So that's very important to touch on in the recorded statement. And I will also say that the date of communication does not have to be specifically from a healthcare provider. It can be from a safety manager or something like that, in which somebody could say, if they visit them in the hospital and say, you know, your heart attack could be related to work. It could be, that could be the date of communication, but you do want to hone in on when specifically the date of communication was. The next thing in investigating the claim is to obtain the pre-employment physicals. And that's to determine, was there a diagnosis of heart disease and hypertension and cancer before the employee was hired. So the General Assembly has only developed the presumption in order to cover injured workers who have had an acceleration or diagnosis of heart disease and hypertension caused by work. And if there's the existence of heart disease and hypertension, and of course, cancer before they were hired, then they're not eligible for the presumption. And it basically would just be an ordinary disease of life and likely a failed claim. And in order to investigate that and to find out specifically whether there was a diagnosis, you would ask first off in the recorded statement, treating doctor, where have you treated? Who's your primary care doctor? Have you ever had any conditions related to your heart, hypertension, cancer, etc.? And then also from the employer to request the pre-employment physicals from the employer. Those might be maintained in a separate file outside of the personnel file. And so be sure to request all records from the employer to include both the personnel file and any pre-employment physicals, because those could be maintained in separate files and have very valuable information, both for the TPA and for the defense attorney. So next one, and I touched upon this, personnel materials. It's relevant to know what is their date of hire. The date of hire, you need 5 years of service for the presumption for heart-lung. The statute is not clear that the service must be a total of 5 years or continuous years of service. And the statute actually reads who have completed 5 years of service in their position. So we actually have I have a particular claim where the person worked as a firefighter and then switched over to another position as a police officer. And so the question is, what did the General Assembly require? And I can't imagine that the General Assembly would allow somebody who had 4 years of service and then took 20 years off, you know, doing something else not related to that, and then working one more year 20 years later would provide coverage for the presumption. But I guess we'll have to see how this new development for the 5 years of service in order to be eligible for the presumption shakes out in the commission and full commission. And then the last thing is to obtain primary care physician records. Was there a diagnosis before the claim? And if so, when? And as I said before, this would be relevant for a date of communication. So there are some times in which a treating doctor would mention in the narrative reports, you know, I talked to him and told him that his hypertension and stress related to his job are probably related. If that's in the medical records and it was noted 3 years prior to the claim for benefits, then there might be a statute of limitations defense that you would have. Also take a note of family history, previous treatment, any defects, congenital conditions that might assist in defending the claim, because you would be able to use that medical evidence as proof that the claim was actually the diagnosis is not related to work, but instead is related to potentially those other conditions, to include genetics and birth defects, etc. All right, and so the last thing I would recommend is obtain, obviously, the contemporaneous medical records. The injured worker has to prove disability in conjunction with the diagnosis. So there has to be an out of work note in conjunction with the diagnosis. So just because the primary care doctor says, I've diagnosed him with hypertension during a regular evaluation for the injured worker, they have not been eligible for the presumption because they do not have an out of work note. So their claim would fail. So the other thing to look at is to look at the reason in which the individual has been taken out of work. So if it's for disability, such as he needs to rest, his blood pressure is way too high, we need to take him out for 3 more days, I would say that that would probably be disability. If he's just taken out of work for the, he was seen in my office today, can return to work tomorrow, you may have an argument there that that is actually not disability. There's no proven disability, and thus he's not entitled, he or she is not entitled to the presumption. So moving on into litigation, couple of things on how to rebut the presumption. If there is a diagnosis of heart disease or cancer, you likely will need a records review or an IME, because what the presumption does is shifts the burden onto the employer to sever the connection between that diagnosis and the employment. And so oftentimes we use IME doctors for these cases. And it should be noted that the IME doctor needs to be able to state that the condition was not caused by the employee's employment and point to a non-work related cause. So such as a congenital heart defect, or that this was related to a condition that is completely unrelated to basically it comes from not from stress or exterior factors, but it is a condition that there's a deterioration of the valve that is just spontaneous. If they can make a statement that is consistent with that, then you would be able to rebut the presumption. And I also just want to make a comment that a lot of IME cardiologists who are unfamiliar with the work comp presumption for heart lung point to, which typically fails. You cannot have an IME, or you can, but it's not helpful to have the IME doctor and cardiologist simply state that there's no evidence that stress, employment stress, causes or contributes to heart disease or hypertension. So the General Assembly has already decided that. They've already decided to make a presumption to allow a law enforcement officer to be eligible for those benefits, and an effort to try to prove to the judge or the commission that the presumption shouldn't apply because the scientific basis for the presumption doesn't exist, that's going to fail. The General Assembly has created it, and we are working under those guidelines. So that kind of IME is not going to rebut the presumption, even if it's evidence-based and you have several scientific citations to prove that. Okay, and so the other thing that we would point to is non-work related causes, as I listed above, congenital heart conditions, birth defects, and I should note also, and this is relevant for IMEs and for records reviews, risk factors alone, such as obesity, smoking, family history, generally are insufficient. So pointing to all those factors, but not being able to exclude exposure at work as a causative contributing factor is not going to rebut the presumption. Okay. So let's move on to the next slide. All right, so touching a little bit more on disability related to the presumption. The commission has held, and the code section in 402 states that there needs to be disability related to the diagnosis in order to be afforded the presumption. And when there's no lost time or no lost wages, the commission has held that there's no presumption proven and no disability proven. So a couple cases, Delaney versus City of Fairfax, which held that the presumption did not apply when the claimant missed 1 day of work but was paid salary. The medical evidence demonstrated he was not disabled as he was taken out of work as a precautionary measure, as he only had an irregular heartbeat for 30 minutes. So basically he had this irregular heartbeat. He made an appointment, went to the doctor, and the doctor said, oh, go ahead and take 3 days off just to, or 1 day off just to take it easy. That was defended and no lost earnings were demonstrated. The person was denied benefits. And the commission will not invoke the presumption when the claimant only makes a claim for medical benefits. So there needs to be, like I said, again, disability and the diagnosis. So the disability period doesn't need to exceed the waiting period. So 1 day of wage loss is sufficient. The commission has denied claims when actual economic loss was not shown due to retirement. And I made a citation here, Shaver v. Department of State Police. And that was one where the claimant was held not to be entitled to the presumption because the claimant did not suffer economic loss due to his heart condition. Claimant had voluntarily retired and was not receiving any wages during the time he was hospitalized and was requesting temporary total disability benefits. And then another case, Arlington County Fire Department versus Stebbins, which is a Court of Appeals case, also had a holding that a claimant who is retired and was unemployed for the preceding 52 weeks may not receive compensation for wage loss because they don't have an average weekly wage. Their average weekly wage is 0. So those are 2 Court of Appeals cases I cite, which touch on disability and what must be shown. Let's go to the next slide. So calculation of average weekly wage for presumption claims, like I said before, the date of communication is deemed the date of injury. And that's when the average weekly wage should be calculated, 52 weeks gross wages prior to the date of communication. And as I said in the preceding slide, when there is the absence of earnings 52 weeks before the date of communications, there are no earnings to calculate average weekly wage. That's another case cited, Newton versus Fairfax County Police Department. Next slide. Okay, so these are just some cases that I cited to, which we can actually put a pin in and circle back on so that we have enough time for everyone's segments. So I'm going to hand it over to, I believe it's Brian McNamara, who will handle this next section.
Hi, hello everybody, and welcome to this presentation. We have a bunch of lawyers who have a lot of topics to cover that are all very interesting, and unfortunately, I think every one of these topics could probably have an hour on its own, and we've got just an hour to do all the various different sections. So forgive me if I go a little fast, particularly at the beginning here. But we're talking about the intersection today of various different benefits programs and how they interact, particularly with the Workers' Compensation Act. So you start with the Workers' Compensation Act, and I think most people here know pretty well what that's about. In essence, workers' compensation covers work injuries that happen as a result of work causes in a work setting, and we have the limited benefits of wage loss and medical and permanency. Go ahead and move the slides, John. Virginia retirement system is something particular to the state municipal employees that we have represented here today. Employees of state, local school boards, local governments and the like have the ability to get into VRS. Some have their own retirement plans. That's all for full-time employees, and there are several exclusions, which again, I don't think the time permits for granular detail. So move the slide, John. We're on to the types of retirement are, ordinary retirement, work-related disability retirement, and non-work-related disability retirement. Today, primarily we'll be concerning ourselves with the work-related disability retirement and how that intersects with these other benefits programs. With the disability retirement, covered disability is cognitive condition, physical illness, injury, various different declines in pre-existing condition can be covered. But the work-related element of disability when it comes to VRS is typically, it's determined by the Workers' Compensation Act. A work-related disability is one which has been determined to be work-related under the Act. Disabling conditions under VRS have to be determined to be likely permanent. Again, if you could advance the slide. Chronic conditions like diabetes, mental illness, things like that, that worsen to a point where job duties can't be done. As I said, pre-existing conditions that substantially worsen to the point where you become disabled. Last point on this slide is the review boards in VRS in particular are looking to make sure that claimants who are getting disability are complying with their medical treatment, and that is something that ties in later. Disability retirement benefits include monthly payments, as well as continuation of life insurance benefits. State health insurance benefits continue if you're a state employee. And there's a health insurance credit that aids with co-pays and deductibles and things of that sort. One of the particular issues with VRS is return to employment. When a claimant returns to covered employment with a VRS participating employer, that disability retirement ends. If they return to employment with an employer that does the same sort of job as their pre-injury employer, even if they're not a VRS participant, the disability retirement will end in that case as well. Onto the Line of Duty Act. This is one, if I'm going to take a moment to confess, I knew very little about this before I was asked to present this material today. So I'm grateful to learn what I have and be able to better advise our clients as a result of doing this presentation today. LODA provides a lump sum of monetary benefits, health insurance coverage to officers, firefighters, and first responders who are killed or permanently disabled from their job duties in the line of duty. Those benefits include monetary payment, $100,000 to public safety officers who die from an unnatural cause. Broadly, that's line of duty deaths. $25,000 payments to public safety officers who die from specified work-related illnesses, respiratory disease, hypertension, heart disease, etc. Those have to occur within 5 years of, or when unnatural cause occurs within 5 years of retirement age, that the payment gets reduced to $25,000. Again, the benefit includes health insurance coverage for any permanently disabled officer, their spouses, dependent children. That benefit ends at Medicare age when a spouse remarries or when a dependent child reaches age 26. Social Security, disability, again, another one that ties in frequently with workers' compensation. To be covered under Social Security disability, you have to be unable to work as a result of some medical condition that's expected to last for at least a year. It can't be a partial or short-term disability. And even all those broad conditions aside, it has to meet Social Security Administration's definition of disability, which can be somewhat arcane in themselves. You have to be below full retirement age, whatever that may be at the time. I think it's currently 72. And you have to have accrued a sufficient number of work credits overall and within the preceding 10 years before your disability starts. The financial payments are calculated based on your own wage history. Medicare enrollment becomes a possibility after 2 years of Social Security recognized disability. And Medicare, of course, is where a lot of the intersections occur with workers' compensation. Once Medicare is eligible, things get a little bit more complex in workers' compensation. They have a vocational rehabilitation program that's not particularly well known. And again, I learned much more about it as a result of preparing for this presentation. There's something called the Ticket to Work program, which some recipients are offered. It's voluntary, and it does offer some benefits to help them get back to work. Final line on that slide just notes that some of the other benefits that are out there are sort of automatic eligibility determination if you are determined to be Social Security disabled, such as SNAP. Other short-term and long-term disability programs that are out there, primarily based in private insurance. There are some state municipal self-insured programs, but mostly it's private insurance. Those are premium based. And so who's paying the insurance premium on those programs can, and in fact is extremely relevant in workers' compensation. Whether it's an employer paying every bit of it, whether it's shared in some fashion between the employer and the employee, or whether the employee is paying 100%. And just to add a tiny note there, some programs are, will give you the low tier disability insurance, and if you want to pay more, you can get yourself into the high tier. That is also often relevant. And those benefits, like I was talking about, there's typically a low tier that pays you about 50% of your pre-disability wage, and a higher tier can go up to 66%. Short-term disability definitionally is usually the first 6 months, at which point a disabled worker would have to transfer over to long-term disability. And long-term usually extends to something reasonably approximating retirement age. Often, actually, there are a lot of them still stuck at 65, despite the fact that that Social Security's retirement age is constantly shifting. Those programs base disability also a tiny bit different than other programs. It is about the inability to work rather than the reasons for the disability, whether it was a work injury or an injury at all. And the definition of disability it falls into some broad categories. Mostly it's either what they call own occupation disability or all occupation disability. Own occupation disability is where all you have to prove is that you cannot do the job that you were doing up till the point of your disability, and all occupation self-evidently is you have to be completely disabled from doing any kind of gainful employment. Those are, and the definition there is also typically a little subtler. It's usually about financially the ability to do anything that would have gotten you up to about 50% or so of your pre-injury earnings. It's not really the ability to do any kind of work at all. Now we move into really, I guess, the meat of this, where we're talking about intersections between all of these different programs. And when you start to think about these things, I think the first and overarching thing that you want to consider is there some possibility that this claimant is being paid twice or 3 times or 4 times for the same injury and getting essentially the same benefits replicated in various different fashions? The General Assembly has in any number of different ways stated quite clearly that it is a public policy of the Commonwealth of Virginia that we pay people 1 time for 1 injury. That's been said in the Workers' Compensation Act, it's been said in the circuit courts, and it's been said in the Supreme Court. And so, anytime you need to find a legal citation for that, there's there's an ability to do so pretty easily. Next slide, John. So what that means essentially is that somebody's probably going to be able to take a credit for benefits that they would ordinarily be paying, but are already being paid through another one of these programs. And since you have all of these different intersecting programs, the question is, who gets to take a credit and who has to, pay full freight? So that is a question that, I'll cover as I intersect these things between the Workers' Compensation Act and each program. But generally, that's the first question beyond, is there a double recovery, is, okay, well, which program are we going to credit it off of? And how is it going to be credited? And as you can see, I cited 2 cases that are delightfully contradictory and saying, you know, the commission doesn't require you to seek approval to claim credit. But then again, if you don't take commission approval before you seek a credit, you risk finding out that you took the credit improperly and being forced to pay penalties and things of that sort. Okay, moving on specifically to the VRS. There is a statute 51.1-156 that defines disability retirement. Again, it shows that work-related disability retirement is defined as a disability which is resulting from a cause compensable under the Workers' Compensation Act. So the Workers' Compensation Act is the adjudicator there of whether or not their work-related disabilities occurred. However, if there hasn't been a workers' compensation benefit awarded under the Workers' Compensation Act, there is actually an ability under 51.1-156 to go to the Workers' Compensation Commission and ask them to make what is essentially an advisory opinion. One of the very, very, very few ways in which an advisory opinion can be obtained through the workers' through the courts in Virginia at all. So if there's no award, you can go to the commission and say, was this something that was compensable under the act, and for which an offset could be claimed. Okay, moving to the next slide. Why is any of this relevant? Of course, because there are benefits which get offset. And so first question that you answer here, who gets the credit? VRS gets the credit, as between VRS and workers' compensation. 51.1-157C is pretty specific. It says that you reduce VRS benefits by the amount that any payments provided under the act. But as I alluded to a little bit earlier, one of the other things that it says is if somebody gets their benefits suspended for failure to cooperate with medical treatment, you continue taking that offset as though they were continuing to get the workers' compensation benefits. Again, this is clearly just a policy decision made by VRS and expressed through the General Assembly that we want to make sure that if somebody's getting state benefits for retirement, that they are continuing to treat. They're not just getting one doctor to say you're disabled and then you stop talking to doctors. You want to make sure that the active treatment continues. Next slide, 51.1-158. This is about lump sum settlements. It talks about the fact that not only can ongoing benefits be offset, but that there is a calculation formula that says if you get a lump sum settlement, we will calculate out how that settlement would have been expressed in weekly benefits, and we will take that offset. The formula is a little tricky. You're determining how much the benefits a person would have received had the lump sum settlement not occurred, and dividing that into the settlement. It seems to me like it's probably a dense enough wording that the best thing to do there is to think about that in advance while you're going through your workers' compensation settlement and determine what, if any, offset is going to be claimed right then and there, rather than leaving this for litigation in circuit court under a pretty vague statute. Okay, so moving on, just a few points that were expressed in Etheridge versus St. Bride's Correctional Facility. Just commission doesn't have jurisdiction to decide VRS credits. They decide whether or not compensation apply or not. Benefits apply. It's not really there to calculate offsets. If you need sort of thing, it's going to be in the circuit court. Next slide. City of Danville versus Tate largely says the same thing. The commission is expected to stay in its lane almost completely and decide workers' compensation benefits, workers' compensation compensability, and leave questions of sick leave, things of that sort to the other courts. Okay, moving on to LODA. So first intersection with LODA is burial expenses. I think the expectation here in 9.1-402.1 is that LODA will act quickly. It will provide burial expenses. And then if there is workers' compensation litigation later, there is obviously a limited burial expense allowance in the Workers' Compensation Act for death claims. The idea is that the Workers' Compensation Act, those benefits would be reimbursed to the LODA fund for anything that it outlaid up to the statutory cap in death expenses under the Workers' Compensation Act. Well, actually, sorry, correct that. The expenses advanced under LODA are actually capped at the same number. So 65.2-512 defines the cap of burial expenses. Again, Virginia retirement system has the administration of LODA, and they have the right to file a claim with the Workers' Compensation Commission to get those benefits reimbursed should that need arise. Next exclusion, and this one's pretty relevant with LODA. This is probably the big ticket item with LODA: health insurance. If you have a person who's permanently disabled as an officer in the line of duty, they get lifetime health insurance benefits extended. However, LODA's guidance documents on that say that we're going to exclude anything that would have been covered or should be covered under the Workers' Compensation Act. We're simply not going to pay those claims. And so the expectation is that attorneys who are knowledgeable, pardon me, of course, inevitably dogs outside the door the second that I start talking. The expectation is that if you have a workers' compensation claim and you settle it, you're going to lose related health insurance benefits unless you find a way to insert some clever language that makes the benefits under the Workers' Compensation Act denied and disputed. All right, moving on to Social Security. And hopefully there's an opportunity to speed through all of this, because I suspect that every single person on this seminar has probably had several seminars about Social Security disability and about MSAs and things of that sort. So I will talk quickly. Okay, Social Security and workers' compensation benefits added together can't exceed 80% of the pre-injury income. So Social Security stops paying. It's an offset that Social Security, not workers' compensation, takes. However, workers' compensation also does get to stop affording COLA benefits to somebody once they reach that 80% of pre-injury wage threshold. COLA benefits under 65.2-709 are limited to that 80% threshold. And then, of course, the other one is the Medicare secondary payer provision, which says that Medicare isn't going to pay for stuff that should have been covered under the Workers' Compensation Act. And it says that in a whole lot more words than I just said, but I did put up the regulation that explains it there for your reference. The reference guide also talks about it. What's interesting and sort of important, I think, as I talk about these things with the Medicare Secondary Payer Act, is to note the fact that Medicare repeatedly says we are not going to pay for the disability. They never, ever really say we're going to go after employers and try to get more money out of the employers if they settle. I know employers have spent a lot of time with the deep concern that if they settle a claim with a Social Security open Medicare claim, that somehow they're going to get pulled back into this. And my experience with reading all of Medicare's guidance documents is that they actually just hit the brakes on paying medical benefits until settlements or things like that are exhausted. Anyway, if you can advance the slide. Okay, so this is the stuff I'm going to assume that a lot of people know. We have these MSAs, and you can submit to CMS if the person who's a current recipient and they're getting $25,000 or more, or if there's a reasonable expectation within 30 months that they'll become a Medicare recipient and the settlement's over $250,000. What I found interesting as I was looking through all of these things was that set of categories down there that actually talks about what is a reasonable expectation that a person's going to get Medicare in 30 months. That's the list right there for your reference. People who currently applied, they've been denied but expect to appeal. 62 years, 6 months of age and older people are presumptively expected to get Social Security in 30 months. Anyway, so if you could advance again. So here again, Ebmsa is the thing that I wanted to talk about just for a second. It's a relatively new option. It's offered by some of the vendors who do MSAs. It involves different allocation methods. You usually do get a lower number with these things, and they are designed specifically not to be submitted to CMS for approval. That you just once they do an EBMSA and they issue their indemnification agreements, it's ready to go. You don't have to do anything else with CMS. The protection that's afforded there is, again, it's for the claimant and their attorney. It's not for the employer, because there's no real evidence out there of CMS pursuing employers or their insurance companies because a settlement didn't properly take into account their interests. So they get indemnification agreements, and it requires 4 years of professional management of the funds by that vendor, because that's the period of time when CMS can look back and have problems with settlements. Last two slides. Disability insurance, the issue there is whether or not credits can be taken and by whom. Credits can, in certain instances, be taken, and they can be taken under the Workers' Compensation Act. So here's where all of the workers' compensation insurers in the audience, you get this credit, but you only get this credit if it's a fully employer-funded policy of disability insurance. Even where employees have paid a portion of the premium, the commission has not allowed this credit. And you can get that credit during the hearing, or you can get that credit after the hearing if you want to go back and deal with that issue later. That's one of the relatively rare exceptions to res judicata until at least recently. The other thing that's needed in that, however, and you can advance the slide, is you do need to see that in the language of the policy of disability insurance, there has to be an exclusion that essentially prohibits there from being recovery under both the short-term disability or long-term disability and the Workers' Compensation Act. That has to be said somewhere in the short-term, long-term disability policy, or they will not award the credit. So again, that's just information that you need to pull before you get that credit or you assert that credit. All right, last slide here, I'll wrap up. Just in general, I know that this was just a lot of information thrown at you and it didn't give you specific answers to specific questions. But what I hope it did do is give you some framework to think about the way that all of these programs sort of tangle together. Question one, do you think that there is a double, triple, quadruple recovery occurring? Two, is this something that you adjudicate in the Workers' Compensation Commission or elsewhere? Three, if there's a double, triple, quadruple recovery, which program gets to save money and which program has to pay full freight? And most importantly is number four, the thing I just want to take a few seconds to talk about. Settlement is always where these contexts come, like in the big kind of dollar issues. If somebody offers you a set of settlement documents where there's language, for example, that would preserve their ability to get lifetime health benefits for their work accident under LODA, do you feel like you've just paid that person a settlement amount which fully recognizes your liability under workers' compensation to pay those medical expenses, and then you're going to still wind up under another program paying all of those medical expenses? If so, you should be settling for less money, or you should be getting that exclusion out of there. Those are all things that have to be thought through as the settlements go on, because while it's true, you may say, yes, we're liable under this Workers' Compensation Act for these things, it's also offset under the other programs. And so preserving the right to pursue things under those other programs without that offset means you should pay less on workers' compensation. Thank you so much for the time, and I'll pass it off to, I guess this is Brian Richardson.
Thanks, Brian. And I appreciate everything you were just talking about. I know it's a lot of information. Some of it's easy to process and understand, and some of it is not. So if there's any questions after this, feel free to reach back out to Brian McNamara or any of the lawyers here at Ford Richardson, and we'll be happy to talk to you about some more of any other details about any of these issues. We're just going to go through some miscellaneous kind of issues that come up frequently for municipalities specifically. Some of them are things that you guys probably know well. Some of them are things that we just kind of want to highlight. So let's go to this first one here. Quite often we see issues revolving around fights with students, fights within the workplace. Just keep in mind that when those issues arise, we are always still trying to figure out if this is something that's arising out of the employment. Obviously, in general, a hazard to which the general public is exposed is not compensable. And so in order to establish that an assault or a fight arose out of the employment, the claimant's going to have to establish that the employee's job exposed them to a particular danger that resulted in the specific injury that was incurred. Next slide here. And so when you're investigating these types of claims, what's going to be the most helpful thing? I mean, obviously, video evidence is the best evidence that you can get nowadays, and a lot of school systems, particularly, there is good video evidence that we're usually able to procure. Always keep in mind that if there is video that is being taken down, that it's something that's being preserved. Was the employee where they were expected to be when this incident occurred? That also comes into whether or not the injury is arising out of the employment. Obviously, if it's not arising out of the employment, there's going to be a defense to the compensability of the claim. Next slide. Another issue, average weekly wage. This comes up frequently with municipalities, because oftentimes there are certain types of workers that aren't on a regular 52-week a year type of job. Sometimes they are seasonal workers. Sometimes they are teachers that have a 10-month contract or a 9-month contract. And so calculating the average weekly wage in those situations is something that we have to make sure that we're doing properly. So the standard formula is the gross earnings for the 52 weeks prior to the accident. There are situations where we wouldn't take the straight 52-week period, and we'll talk about those in the next slide. Quabs, do you want to chat about average weekly wage with seasonal workers?
Yeah, just very briefly, again, because we're limited on time, but as a general rule, if a teacher is on a 52-week contract, but they only work 42 weeks out of the year, their average weekly wage is still going to be calculated using those 52 weeks, unless they're doing similar employment during their summer months. However, there are some school employees who might just be seasonal. So if that seasonal employee works 8 weeks, for instance, their average weekly wage would be calculated by dividing their earnings for those 8 weeks by 8 rather than the 52, as long as they are looking for other employment during the remainder of the year. The concern there is obviously if you only work 8 weeks and then get injured, it artificially inflates your average weekly wage. And so there's certain case law out there, there's lines of cases you can look at. But if you have any questions about a particular case, don't just assume that it's 52 weeks for teachers and seasonal employees, because there are various ways to calculate depending on the type of contract that the employee has.
Next slide here. In the next two issues we'll move kind of quickly because they're, I think, things that we'll be able to cover pretty quickly. Falls off of buses. This is something that occurs frequently with municipalities. Big picture here, we're always still going to want to make sure that there is an added risk to the employment. We're going to want to know whether and we can go to the next slide, whether there was a defect in the steps, damage to the steps. Those are going to be the things that will dictate whether or not the injury arose out of the employment. If the steps are ordinary height and configured in a typical way, we're going to be able to defend those types of cases. Next slide. Also, when we're defending those claim cases, video evidence obviously is still helpful. Experts are going to be helpful if we have to take some measurements and make sure that everything is up to code and that there weren't any crazy defects in the steps themselves. Timely photos are always helpful, and so are contemporaneous statements made by the claimant and any other witnesses. Next slide. So the last thing we'll talk about here is the unjustified refusal of light duty. Generally speaking, and go ahead to the next slide. It's always great when employers are willing to accommodate light duty restrictions, but oftentimes injured workers still won't accept it. And so what we're trying to figure out and what we're trying to, the kind of evidence that we need to defend those cases where someone has unjustifiably refused light duty or where there has been a bona fide offer of light duty work by the employer within the claimant's restrictions, and the claimant still just unjustifiably refuses the job. Next slide. We'll go to the next slide, because I think actually the next thing is just slips, trips, and falls. Similar to school buses, we're pretty much looking at the same analysis, whether or not there was a defect and whether or not we were able to demonstrate that that defect is basically the causal connection between the accident and the injury. Next slide. And actually, that's pretty much it. We'll go ahead and I'll go to Quabs for this little last section. To the extent that we have time, I'm actually not sure if we do have time for it. Obviously, we'll chat about it, but if folks need to peel off, we'll obviously be sensitive to that as well.
Yeah, and I'll do this in about 30 seconds, just touching base on the case of Collada v. Fairfax. And basically, without going into too much detail, the county was paying an injured worker ongoing wages in lieu of compensation pursuant to an award, but they never terminated that award with the commission when the claimant returned to work. And the commission held that his ongoing wages, even though he had no wage loss, could not be substituted for actual termination of the claimant's award with the commission. So it's just a reminder, when there's an open award in Virginia, you really need to terminate the award either through stipulated order, through termination of wage loss agreement forms, or through settlement. Don't assume that because the injured worker is getting their wages that the award has been terminated. There has to be an official termination with the commission. That was the main takeaway that we wanted to remind people of, because we know that there are many cases where counties and municipalities pay the injured workers ongoing wages instead of just compensation. So, and with that, again, in the interest of being sensitive to your time, we'll end the presentation, and I will throw it back to Scott for any closing words.
Sure. Well, thank you all very much. Obviously, a lot of content, and thank you to the panelists for putting together such excellent content. If folks have questions about any of the material, feel free to reach out to any of us, and we'll be happy to provide you with additional information. But again, thank you all for your time on this beautiful afternoon, and we wish you all a very happy Thanksgiving.
Take care, everyone.
Thank you.